Hey guys, today we're going to talk about vicarious liability. What is vicarious liability? Vicarious liability simply means holding an employer liable for a third party's injury caused by the wrongful act of his employee if the act had been committed during the course of the employee's employment. So for example, the driver of a lorry is employed by employer. During the course of his employment, the lorry driver hits a pedestrian on the road. So the pedestrian, instead of suing the lorry driver, who probably doesn't earn a lot of money, probably less than $2,000, the pedestrian who was injured in the accident would then sue the employer under the doctrine of vicarious liability. The reason is because one of the reasons is because the employer has more money, deeper pockets, and then the plaintiff would use this doctrine to say that the employer is liable to the pedestrian because the accident was done by the employer's employee, the lorry driver, in the course of his employment while driving the lorry. Another example would be an employee's negligence in not following safety procedures at work, which results in injury to another party. So the employer would be held liable for the employee's negligence to third parties for breach of safety measures, even though the employer was not negligent at all. By imposing vicarious liability, the court's aim is to provide just and practical remedies to a third party injured by the wrongdoing of an employee. The courts use a two-stage test to establish whether an employer is vicariously liable for the acts of his employees. The first stage of the test to determine vicarious liability is to decide whether there was a special relationship between the parties that would make it fair, just and reasonable to hold the employer vicariously liable for the acts of his employee. The first factor, the court will look at the nature of the relationship between the employer and the party who caused the injury, for example, the employee, whether it was a special one, making it fair, just and reasonable to hold the employer vicariously liable. If the party is an employee with the employer and there is an employment agreement, it is likely that the court will find that there is a special relationship between the employee and the employer. However, if it's an independent contractor, the court will not be likely to find a special relationship. The second factor, whether the employer would be more likely than the employee to have the financial means to compensate the victim and could have been expected to insure himself against such liability. Third factor, whether the wrongful act had been committed as a result of work done by the employee on behalf of the employer. Fourth factor, whether the employee's work was part of the business activity of the employer. If it's not part of the business activity, for example, he does something during lunch and which caused an accident, then the court may not want to find that there's a special relationship. Another factor that the court will consider is whether the employer, when hiring the employee to do the work, had created the risk of the employee committing the wrongful act. The court will look at the circumstances of the job scope of the employee, whether there was a risk that he would commit such a wrong, breach safety protocol, cause an accident. The final factor that the court will consider is whether the employee had been under the employer's control at the time when the wrongful act was committed. If the employee was out doing lunch, doing his own stuff, or the employee was committed the wrongful act after he had finished work, then probably the court would not find that such a relationship exists. So thanks for watching this introductory video on vicarious liability. Do stay tuned for the next few videos.